So for final exam, you will have 5 questions. Choose 3 out of 5. So law of contract will come out in your final exam. And for this semester, we have finalized the topic that will come out for final exam for law of contract. Just focus on the void and also voidable. Void and voidable chapter. The audio and slides on the void and voidable has been shared with you. I don't know whether have you listened to all the audio or not yet. Have you listened to the audio class? Okay. So I know Liana said that yes, and yes, so I already listened to the audio. So right now we want to look at the sample of question. It relates to void and also voidable. Okay, please sign in your attendance. I put the QR code link in your WhatsApp group. Okay, by looking at the question number 1A, okay, take your time, 2 minutes, try to figure out. Okay, read the question, try to figure out what is the issue, okay, in this question. And before you you determine what is the issue in this question, you have to know this question fall under which chapter or which subtopic first. Okay. Maybe different. You determine the issue. Okay, for question number 1A. Okay, I want to do a little bit recap on the audio that has been shared with all of you. Okay. For the chapter of intention, okay, what you should bear in your mind is that for the intention, we know that there is no such provision in the Contract Act 1950 mentioned about the definition of intention, and the definition of intention can be looked at under the common law, and there is presumption, okay, on the existence of intention. Okay, for social and domestic agreement, we presume that there is no intention unless the contract been put in written down, okay, put in black and white agreement. Okay, so to highlight, okay, the issue of presumption in social and domestic agreement, okay, please refer to the case of Balfour versus Balfour and also Merritt versus Merritt. The decision in both cases is different, okay, due to the situation, in order to determine whether there is an existence of intention or not in that case. And for commercial and business agreement, okay, business and commercial agreement, we presume that there is intention, okay, to create legal relation between both parties involved in the contract. So you can support your argument by discussing the case of Carlyle versus Carbolic Small Ball Company. For capacity to enter into a contract, we know that the general principle to enter into a contract is that the person must be an adult, mature person who know the consequence, okay, the consequences, can know how, who can weigh the consequences of a contract, and also can form rational judgment. Okay, that one is the general principle. Okay, relates to capacity to enter into a contract. So from this general principle, we can extract out kids, okay, or infancy or insanity is considered as a group of people who have limitation to enter into contract. However, under the law of contract, uh, infants or kids or and also insane person can also enter into a contract on certain uh, agreement. Okay, for example, for insane for an insane person, okay, we know that based on section 12, subsection 1, 2, and 3. Okay, section 12, subsection 1 give clear status about uh, unsound mind person where their contract is considered as a valid contract if they enter into the contract in the situation of he or she is sound mind person. So we look at the time of making the contract, and section 12 subsection 2 and 3 mention about the situation of on and off uh, of intent. Okay, so the general principle that we have to hold is that we look at the time of making the contract. That person is in the situation of sound mind. So you can use the case of Cik Sumiti versus Maha Private Limited in order to show that, okay, for an insane person, they can enter into contract, and we look at the time of making contract. If they are in the situation of sound mind person, and the contract is considered as a valid contract. And then for kids, they also can enter into contract, okay, for certain contracts, okay. For example, scholarship contract, contract of marriage, contract of indemnity, contract of service, um, contract of necessaries. So this insurance contract, so all of this contract can be entered by kids, and certain contract must be subject to the approval of parents. Okay? Means that the liability will be on the parents. And for void contract, okay, we have three types of void of contract, okay, which is we have two types, legal and also illegal contract. But what we should focus is in terms of legal contract, which relates to restraint of marriage, restraint of trade, and also restraint of legal proceeding. And for each restraint, they have their own exception. Okay, for example, for restraint of marriage, we know that we cannot restrain someone who have come to the age of majority. Okay, for example, a man at the age of 30 years old cannot be restrained from marriage. Okay, because that one is considered as a void contract. Okay, unless the contract of marriage involved between kids. Okay, so that one can be restrained by parents. And for restraint of trade, we know that for for, for legal trade, okay, or legal profession, if someone cannot restrain any other person or prevent any other person to proceed, okay, with legal profession, okay, and that one is considered as a void contract, okay, unless that person can prove there is an element of goodwill and also there is partnership between both parties. And for restraint of legal proceeding, we have no right at all to restrain any other person to get legal counsel, to get legal to obtain legal proceeding, unless the contract involved of contract scholarship. If for contract of scholarship or arbitration cases, we can restrain other people to bring the case to court. And for voidable contract, we have learned that, yeah, under section 2I, okay, avoidable contract is a valid contract at the first place. But later on, due to the mitigating factors, okay, factors which can stain the contract, that can stain a valid contract, later on turn the valid contract into a voidable contract, i.e., when the contract has an element of force, okay, or undue influence, or fraud, or misrepresentation, or mistake, then the contract can be considered as a voidable contract. That one is under the topic of voidable contract. And then for termination, we have 4 ways, okay, to terminate, to resign, to stop the contract. I.e., the contract can be ended by another agreement. Contract also can be ended by performance of the contract, okay, by breach of the contract, and also due to frustration or impossibility of contract, okay, to proceed. And under the chapter of remedies, there are 4 methods of remedies that provided under the law of contract. We have damages or compensation, contumacy, specific performance, and also injunction. Okay, damages is considered as a normal claim in the case of breach of contract. Okay, normal lah, biasanya bila berlaku yang pelanggaran kontrak, orang akan mohon pampasan. Okay, so there are several types of damages we mentioned in audio. Okay, we have nominal damages, special damages, exemplary damages, for example. So all of those damages can be provided by law of contract, okay, for the people who involved in the case which has an element of breach of contract. Then we have contumacy. For contumacy, the formula to recognize the case which involves contumacy is that part or partial, okay, of the performance has been done by someone, referring to a contract. Okay, maybe it's also known as a quasi contract. Okay, what is important here is that part performance has been done, okay, but the rest cannot be proceed due to certain reason that cannot be avoided. Okay. Contohnya kalau kata a novelist has an agreement with a publisher to produce 10 books, okay, 10 novels per year, tapi disebabkan due to COVID-19 that novelist cannot go out from the house, just stay at home. So the idea tu tak datang, to complete all the 10 novels. Tapi pada tahun tersebut, okay, but in that year, that novelist only can produce 6 novel out of 10. So kita katakan half of the performance has been done by that novelist, and that novelist is entitled, okay, for the payment from the publisher. Walaupun dia tak siapkan sampai 10, tapi dia dah siapkan separuh daripada performance yang dituntut dalam kontrak. That one is contemporary. And for specific performance, that one is decree or order by the court, okay, where the court order parties who involved in the contract to follow whatever has been stated in the contract. Katakanlah, two parties who involved in a contract have dispute outside of the court, bergaduh kat luar court, and then bawa case, bring the case to court, and the court just order them to follow whatever has been stated in the contract. Apa yang terkandung dalam contract, just follow to settle the issue between both of them. That one is specific performance. The order comes from the court. And then for injunction, halangan. Okay, so there are several types of injunction. We have temporary injunction, permanent injunction, prohibitory injunction. So all of that can be applied, okay, from the court. So this one is considered as a recap from what have you listened, okay, from the audio. So sekarang ni kita nak bincangkan, okay, want to discuss on the questions which relates to the topic of void and also voidable contract. So dah habis baca dah? Ni soalan nombor 1A. Have you finished? Read the question 1A. class?
Yes, doctor.
Okay. So looking the situation between Ruby and Rosie right now. Okay. Ruby, the owner of Elegante Wedding, a famous wedding planner company in Nilai, recruited trainee Rosie to assist her in running the wedding events. Okay, the agreement between Ruby and Rosie provided that after the expiry of 2 years contract, Rosie should not practice as a wedding planner in Nilai within a radius of 5 kilometers of Ruby's premise for a period of 1 year. Immediately after the expiry of her contract of employment with Ruby, Rosie opens a wedding planner company 1 kilometer away from Ruby's business. Advise Rosie on her rights. Okay, so this question fall under which subtopic?
Void contract.
Yes, void contract. Okay, good. Restraint of trade. Okay, void contract, restraint of trade. So it is clear, okay, from the question. Okay, the issue is there is an agreement between Ruby and Rosie where it is stated that Rosie should not practice as a wedding planner in Nilai within a radius of 5 kilometers of Ruby's premise for a period of 1 year. Okay, but what happened after that, after the expiry of the contract between Ruby and Rosie? Rosie opens a wedding planner company just 1 kilometer away from Ruby's business. Okay. So you said that okay, this is fall under restraint of trade, okay, void contract, restraint of trade. So which section okay, apply? What is from section 28? Good. Tiga. Section 28 apply in this case. Yeah. So apa case yang kita nak guna pakai to support our argument right now? Ingersoll versus Anthony Wilson. Okay, if you use the case of Goldsoul versus Goldman, means that you if right okay for Ruby to use an element of uh, goodwill there. Okay, okay. So the general principle is that okay if you want to have Rosie in this case, okay, if you use Ringersworth versus Anthony Wilson, then the contract between Ruby and Rosie is considered as restraint of trade, and that one is a void contract, contract batang. Meaning, if the contract is a void contract, null contract, then the contract cannot be enforced. Okay. So unless if you want to use the case of Goso versus Goldman just now, means that you want to highlight there is an element of goodwill there, carry goodwill there. Okay, so you can stop Rosie, okay, to open a wedding planner company 1 kilometer away from Ruby's business. Okay. So kita tahu if you can, okay, if you can prove on that, okay, 1 kilometer saja means that not far away from the Ruby's premise, then it should be a conflict there. Okay, sebab kita tahu apa ni Rosie ni dah lama dengan Ruby, and then 2 tahun, okay, okay, dah jadi recruited, okay, a trainee by Ruby in this case, and then other people pun kenal dia. So if you can prove okay, the element of carry of goodwill there, then Rosie can be prevent to open a wedding planner company 1 kilometer away from Ruby's business. So it's up to you. Okay, it's up to you whether you want to use it as okay as a restraint of trade, which is considered as a void contract, or if you want to highlight on the issue of carry goodwill there, then Rosie can be from continue from proceed to open a wedding planner with it just 1 kilometer away from Ruby's premise. Okay. So, sama ada you nak bincangkan jawapan ni menggunakan general principle ataupun yang jatuh di bawah exception. Cuma kena ingat gunakan case yang betul lah. Okay, kalau you kata that one is restraint of trade, then you use Ringersworth versus Anthony Wilson. Tapi kalau kata you nak highlight on the issue of carry goodwill dia, nak letakkan point partnership, okay, as an exception, tak boleh sebab tak ada partnership between Ruby and Rosie. So you want to use the elements of carry goodwill, then you kena pakai case Bolso versus Goldman. Okay. Itu jawapan dia kena selari lah dengan case yang you kena pakai.
Doktor,
Yes.
for the answer, kita kalau jawab kan kita kena tunjukkan kes kepada yang Ringersworth tu kan untuk macam evidence untuk buktikan kes ini relate dengan kes voidable contract yang ni. Tapi yang pasal Ruby dengan Rosie ni kita kena explain dalam answer kita tak dia orang punya situation. Oh terus direct ke bukti kes yang Ringles and Wilson Anthony.
Okay, you kena gunalah ayat dekat dalam, okay, which a sentence yang nak menunjukkan bahawa adanya restraint of trade there. Okay. So kalau kata you nak letakkan ini sebagai okay, sekarang ni clear from the fact of the case, it shows that there is an element of restraint of trade. Sebab kita nampak Rosie should not practice as a wedding planner. Kita tahu business wedding planner ni as legal profession, maksudnya valid profession under the law. Tak ada larangan pun untuk buka wedding planner. Tapi bila diletakkan halangan yang tak boleh buka dalam 5 kilometers away dalam tempoh 1 tahun, so kita nampak ada halangan dekat situ. Okay. So cuma bila you nak bincangkan, is either you want to show that restraint of trade itu adalah satu perkara yang void ataupun ianya could fall under the exception. Okay, kalau kata you nak letakkan bahawa ini jatuh kepada restraint of trade which is considered as a void contract, then you kena masukkan case Ringersworth versus Anthony Wilson tadi. Tapi kalau you rasakan not fair to Ruby sekarang ni, okay, so you want to help Ruby sebab ni kat sini kata Rosie opens a wedding planner company 1 kilometer away, tak jauh pun daripada Ruby business. Okay, Ruby's business. So nampak ada competition lah dekat sini. Dan mungkin orang yang dah kenal Rosie masa Rosie bekerja dengan Ruby boleh pergi kepada Rosie. So tinggal customer Ruby ni dah tak tinggal ramai dah. So kita katakan the carry goodwill there. Okay, Rosie ni carry goodwill yang selama mana dia bekerja dengan Ruby dulu, dia dah kenal ramai customer Ruby. Dia bawa customer tersebut ke tempat baru dia yang tak jauh daripada Ruby's business. So if you can prove on that, then you have to use the case of Coastal versus Goldman. Which part yang you nak pakai? Tapi kalau kata you nak bagi stop kat situ saja, kata you nak sampai restraint of trade je, tak kisahlah dia buka 1 kilometer je pun, memang dia ada hak untuk buka kedai pun. Okay. Nak buka sebelah pintu Ruby pun boleh. Okay. Kalau you rasa okay benda tu adalah bukan satu larangan untuk teruskan business wedding planner ni. Okay. So depends on your argument. Cuma saya cakap you kena selarikan case yang you nak guna pakai. Kalau you guna yang jatuh bawah exception, sebab kita tahu every restraint yang kita bincang under void contract kan, restraint of trade ke, restraint of marriage ke, restraint of legal proceeding ke, ada exception dia. So it's either you nak guna general principle ataupun you nak guna ianya sebagai satu perkara yang jatuh bawah exception. Is it clear? Alright. So kalau kata mungkin lah ada setengah orang kata alah tak kisahlah dia nak buka sebelah pun, mungkin dia jadi trainee je, orang pun tak adalah kenal sangat dia. Bila orang datang pun orang jumpa Ruby, orang tak jumpa dia sebagai trainee. Okay. Tapi mungkin kita boleh juga buat presumption there. Mungkin bila dia trainee, Ruby yang owner ni kadang-kadang mungkin tak banyak masa berada di tempat kerja, di premis tempat kerja dia. Trainee dia yang banyak uruskan kedai, katakanlah macam tu. So you can make any presumption to that. Okay. Cuma yang penting you punya jawapan tu kena selari. Jangan pula you cakap benda ni jatuh exception tapi you pakai case Ringersworth versus Anthony Wilson. So that soalan B pula, okay, this one is considered as a direct question ni. Okay, you baca je you dah tahu dah It is refer to what issue lah kan. Okay, describe the types of doctrine of mistake in accordance with the Contract Act 1950 and decided cases. Okay, so we have how many types of doctrine of mistake in terms of issue of mistake? For mitigating factors, okay, mistake is one of it. Ada berapa jenis mistake? Okay, we have three. Okay, three types of mistake. Okay, so apa dia tiga tu?
Doctor, can you hear me?
Ah,
Yeah, you can hear me, right? For just now, the question A, right?
yeah,
Just now, for the question A, because it's 10 marks for the question, right? So when
yes.
we answer the question, right, can we like put both explanation for the case about the Winklevoss versus Wilson Anthony and Goso versus Goldman in there? Like,
You want to put two
explain
situation.
for- yeah,
You want to explain in terms of using the general principle and also exception.
yeah,
Okay, so if the question have the what we call the possibility of that, then you can answer both. Okay, but there is no extra marks. It just for this question, it refers to only one because we know that there is a general principle and exception. So I cuma nak lihat you punya apa ni presumption or your perception in terms of this case. Either it should be used general principle ataupun using exception. Cuma bila you nak gunakan it is fall under the general principle, which part which part or which sentence in the contract shows it relates to the general principle. And kalau kata you nak guna it is fall under the exception, ayat mana yang ada dalam kontrak, dalam case ini menunjukkan bahawa ianya adalah exception. Kalau kata you letak dua-dua tapi dua-dua tak strong pun tak membantu you juga. Tapi kalau kata you guna satu tapi it's complete answer, okay? So you akan dapat markah penuh. Tapi kalau bila you letakkan dua-dua, I akan pilih lah which one yang lagi complete jawapannya lah. Maksudnya apa ni, bila you nak extract out the issue of the case, you kena refer to what sentence, okay, dalam case ini yang membawa you decide kepada satu keputusan.
okay, understand.
So,
Thank you.
so kena lengkap lah jawapannya. Okay. So kalau kata it falls under exception, so kena mention lah exception. Jangan terus keluar letak okay you using it Goso versus Goldman. So kena terangkan lah exception dia tu apa macam tu. Okay, soalan B tadi, types of doctrine of mistake. Okay, so we have three types of doctrine of mistake. I know Lena cakap by both party, by one party only, and mistake as to law. Okay, we have mistake by both party. As per section berapa? So bila you nak terangkan, you kena terangkan in detail lah. Okay, section 21. Okay, mistake as both party relates to section 21 and if the contract consists of mistake by both party, that contract is considered as a void or valid contract. Okay, it's considered as a void contract. So it means that the contract cannot be enforced. So what case that can be applied for mistake as both party? Nak masuk case apa? Yon kenapa keluar masuk? Line dia tak okey. Okay, so case apa kita nak guna pakai? Okay, we have Raffles versus Wishelhorst, we have Couturier versus Hesty. So you boleh pakai mana satu case. Once you letakkan nama case, okay, tuliskan fakta dia. Tuliskan fakta case tersebut. Okay, so right now, okay, kita dah selesai bincang satu type. Okay, and then we go to the second type. Okay, Second type of the case is, second type of mistake is doctrine. Doctrine of mistake is mistake by one party only. So mistake by one party only is considered as a valid or void contract. Okay, mistake by both party considered as a mistake by both party is considered as void contract. Mistake by one party only is considered as apa ni? Apa jawab? Valid contract. Okay, valid contract based on section 23. Okay, so you masukkan case Templin versus James. Yeah. Not voidable contract means valid contract. Tidak boleh batal. Okay, tidak boleh batal means it is a valid contract. Mistake by one party only. And then mistake as to law. Okay, we have the situation of mistake as to law which enforced in Malaysia, and also mistake as to law which is not enforced in Malaysia. Okay, so for the law which enforced in Malaysia, the contract is the contract is valid. Okay, for the mistake as to law which is not enforced in Malaysia, the contract is voidable. Okay, the contract is voidable. So you kena masukkanlah based on the section. Section apa? Section 22. Okay. So kalau kata ada case, masukkan case. Tapi kalau tak ada case, you have case yang ada decided cases lah. Okay, for example, we know for the situation of mistake as to law, okay, the ignorance of law is not an excuse. Kita tak boleh nak cakap bahawa kita tak tahu berkenaan dengan suatu undang-undang tu dalam satu negara tu dianggap sebagai satu excuse lah. Kita tak boleh nak gunakan alasan tersebut. Okay. Jadi kalau kata untuk apa ni, orang Thailand for example, di negara Thai mereka menunggang motorcycle, riding a motorcycle without helmet is not considered as an offence. Tapi kalau mereka datang ke Malaysia, okay, riding a motorcycle without helmet, then that one is considered as an offence. Okay, cannot use the elements of ignorance as an excuse. Sama juga lah situasinya kalau kata kita ni berada di luar negara. Okay, for example, in the case of mother yang pukul anak, okay, dalam a mother from Malaysia yang tinggal di Sherman and dia pukul anak dekat sana. So dia tak boleh nak gunakan ignorance of law. Kat sana dia kata tak tahu bahawa memukul anak di negara luar tu satu kesalahan. Okay, because we know that okay, the situation of kids ni, kalau kata di negara luar, kids is considered as property of the government. Anak-anak dianggap sebagai harta satu-satu kerajaan. Okay, jadi kalau kata berlakunya abuse of a child, maka government will take over. Okay, kanak-kanak tersebut di bawah penjagaan government lah. Okay, jadi kita tak boleh nak cakap ignorance of law in the situation bila mana kita berada di negara, mana-mana negara, if we reside in that country, kita tak boleh katakan bahawa kita tak tahu undang-undang negara tersebut. And okay, so you boleh masukkan as long as the case is decided case, bukan case yang tiba-tiba je baru muncul waktu tu tak nak lah. Okay, tiba you dapat wahyu ada kes terkini yang saya sendiri pun tak pernah baca kes tersebut, tak nak. Kita nak letakkan kes yang decided cases, even kes tersebut saya tak bincangkan dalam kelas, tak ada letakkan citation dia dan sebagainya, tapi that one is a decided case, you boleh letakkan. And then we go to the 1C. Let me go to 1C. One evening, Baka was told by his spiritual advisor Hassan that their religious group urgently needed a new meeting place, and Hassan reminds Baka in a friendly way of the large bungalow which Baka owns in Morit. Hassan also reminds Baka that whatever action he may take must consider it as a benefit of their religious group. After the transfer of the said bungalow, Baka was expelled from his religious group without any grounds. He now wants to set aside to transfer the said property. Get 10 marks. So based on this short scenario, based on this short scenario case, Apa jawapan dia? Okay, this one fall under what? Okay, voidable contract, undue influence. Okay, good Roha. Okay, I know bersama. Okay, voidable contract fall under undue influence. So what leads you to the answer? Kenapa you cakap that one is undue influence? Apa elemen yang ada kat dalam, apa point yang ada kat dalam cerita ni yang membolehkan ini adalah undue influence? Which part?
Hassan's, I think like Hassan's authority over Bakar.
Okay, so we look at the relationship again between Hassan and also Bakar here. Okay, there's a fiduciary relationship there. Hassan is considered as religious advisor and Bakar is the follower. So kita nampak that Hassan in the position of dominant party that have the possibility to take advantage over Bakar lah. Okay, over Bakar. So in this situation kita kata memenuhi requirement of undue influence dan it's also if you look at other sentence pun kita boleh nampak where Hassan reminds Bakar that whatever action he may take must consider it as a benefit for their religious group. Okay, so kita nampak dekat situ the dominant party have tendency to take advantage over a weak party. Okay, because bila mana after the transfer of the state bungalow, Bakar later on was expelled from his religious group without any grounds. So bila dah ditendang keluar daripada kumpulan keagamaan ini, barulah Bakar sedar diri dan want to set aside the transfer of the state property. Okay, so sekarang ni this question jelas merujuk kepada undue influence. So which section yang kita nak guna pakai? Section apa untuk undue influence? Okay, section 16. Okay, so you have to put section 16 subsection 1. Okay, there is dominant party, ada weak party. Okay, the definition of undue influence, and section 16 subsection 2 berkenaan dengan fiduciary relationship. Okay, di mana adanya hubungan religious advisor dan juga follower there, and the burden of proof will be on whom? The burden of proof for undue influence. BOP and the siapa? Who should prove in this case? Who should bring the evidence? Okay. Okay, so burden of proof will be on Hassan. Okay, will be on a defendant. Okay, you still remember, kita sempat bincangkan berkenaan dengan voidable contract that day. Okay, di mana untuk force, burden of proof will be on plaintiff, tapi untuk undue influence dia akan jadi otherwise. Okay, the burden of proof will be on the defendant. Okay, so Hassan will bear the burden of proof. He has to prove to the court that is not do any undue influence or influence Bakar to transfer the bungalow to Hassan. So apa case yang kita nak guna pakai? Case apa yang kita nak masukkan? Undue influence. Okay, boleh pakai Cik Sun binti. Okay. This is Maha Private Limited. You also can use case Salwat Halim versus Haji Abdullah. Boleh masukkan case tersebut lah. Okay. So what is the consequence? Okay, when we talk about the undue influence, sekarang ni kita bincangkan kes ni jatuh bawah undue influence. So consequence ataupun remedy for the case involve undue influence. Okay, section 66. Before section 66, okay, section 66 ni maksudnya in this case Bakar Hassan has to transfer back the bungalow to Bakar. Okay, before that section 20, okay, voidable at the option of the parties involved in the contract. So kita masukkan lah semua tu. Okay, kita masukkan remedies. So it is clear from your explanation that this case was under undue influence and you have provide the solution, okay, for this case. Okay, jadi kalau kata bila final exam nanti banyak sangat case nak baca kan, banyak sangat case nak memorize, ingat nama case saja, tak ingat fakta, just letak je lah. Cuma mungkin markah tak penuh lah. Tapi no worries lah, markah 0.5 pun penting untuk final exam ni. Okay. Kalau kata ingat fakta case tapi tak ingat nama case, ingat cerita pasal seorang isteri ditinggalkan, okay, dia bila kematian suami dia tak dapat even a single cent, tapi tak ingat nama Salwa Salim, ingat Salmi ke apa ke, tak. So cannot recall the real name. Letak je lah fakta case. Okay. Walaupun nama case tak ada. Jadi apa yang you ingat you kena letakkan. Cuma itulah yang membezakan markah you dengan markah your friends nanti. Okay, sebab sekarang ni untuk quiz, mungkinlah markah you tak beza sangat dengan kawan you. Okay. And then untuk test buat dalam group, so markah mesti sama. Untuk assignment pun sama. Tapi bila final exam ni lah, kadang yang membezakan, okay, markah you dengan markah kawan you lah. Okay, mungkin kawan you ni write the answer, okay, completely give all all the evidence yang diperlukan lah, masukkan section, masukkan case pun lengkap dengan fakta, okay, dan ada decision dekat situ. So mungkin yang membuatkan you kurang markah sedikit kalau kata you letak nama case tak ada fakta, so you still got marks tapi tak tinggi lah. Okay. So apa yang you ingat just masukkan, jangan tinggalkan, biarkan kosong. I know lah bila final exam ni macam-macam nota lah saya akan jumpa nanti. Minta maaf doktor, kes tak ingat, panjang lebar dia punya nota kat bawah tu. Kadang dia tinggal ruang kosong, macam nak minta IC ke, I don't know lah why. Ataupun mungkin ditinggalkan kosong dulu, nanti dia ingat, dia akan masukkanlah nama kes tu kat situ. Okay. Tapi apa yang you ingat, just put it there, jangan tinggalkan. And then discuss the issue of restraint of marriage based on the Contract Act 1950 and decided cases. Okay, kalau for this kind of question, kalau tadi, okay, untuk yang soalan datang dalam short scenario case, you have been given the opportunity, you nak pakai general principle ataupun you nak pakai exception. Tapi before you nak sampai to the level of exception pun, you mesti bincang general principle dulu, barulah keluar pengecualian dia. Okay, so tapi kalau untuk soalan yang direct macam ni, the issue of, okay, discuss the issue of restraint of marriage, then you kena letakkan general principle dia apa, exception dia apa. Maksud like macam letak nota lah. Okay, dia berbeza dengan soalan yang berbentuk short scenario case dan juga soalan yang direct question. Okay, so for restraint of marriage, kita rujuk kepada section apa? Section 27, void contract. Okay, section 27. So, kena bincangkan lah, okay, apa content of section 27 tu. Kita tahu bahawa we cannot restrain someone, okay, we have come to the age of majority to enter into a contract of marriage. We know that under the Islamic Family Law Act pun, okay, for a girl at the age of 16 years old and for boy, at the age of 18 years old, they can get married. Tak perlukan approval from parents pun. Okay. Kanak perempuan berusia 16 tahun, lelaki umur 18 tahun boleh kahwin without getting any approval from parents. Tapi kalau kata under age, have to get the approval from parents and also approval from court. That one is stated under Islamic Family Law Act. Okay. Kalau kata untuk yang dah sampai age of majority, 18 tahun, boleh get married lah. Tanpa perlu dapat approval. So, bincangkan untuk restraint of marriage ni, dia punya general principle, and then masukkan exception dia apa. Kalau kata in terms of marriage, okay, between kids, okay, maka the contract of marriage, okay, can be restrained by parents or any other people lah. Okay. Boleh dihalang untuk masuki kontrak kahwinan melibatkan anak yang bawah umur. And then masukkan case. So case apa yang nak masukkan? Okay, Shaw Brothers Limited tu boleh masukkan. Okay, di mana Shaw Brothers Limited dia tetapkan, dia buat penetapan untuk actress, dia tak boleh kahwin. Okay, selagi mana kontrak wujud di antara actress dan juga Shaw Brothers Limited. Ni zaman Ramli dulu lah. Okay, Shaw Brothers Limited ni ada di jalan apa ni, ada di Singapore at that time, and then kemudian berpindah ke Jalan Ampas. So mungkin kalau katakanlah you tak ingat kes Shaw Brothers ni, tak ingat, tapi ingat kes Wawa Zainal. Okay, if you still remember, kes happen in apa ni, dalam industri filem lah. Okay. Wawa Zainal bila dia kahwin dengan husband dia, apa nama husband dia? Mesti you all ingat. Ada Zafir kan. Okay, so at that time, perkahwinan tersebut, mereka dah kahwin lama tapi tak reveal kahwinan tersebut sebab ada kontrak antara Wawa Zainal dengan MIG, pemilik dia David Teo, di mana Wawa Zainal ni tak boleh kahwin, kerana ada kontrak untuk for a certain period of time. Jadi kita nampak that one is considered as a restraint of marriage, which is a void contract. Ini satu kontrak batal which cannot be enforced. Tak ada tindakan pun boleh diambil pada Wawa Zainal kalau dia kahwin. Doktor dalam final boleh guna kes macam tu? Boleh guna, as long as it is a decided case. Untuk kes macam tu kita ada decision. Untuk kes Wawa Zainal tu ada decision dia. Dia dah digunakan lah as precedent. Okay, banyak macam kalau kata kes before this, kes yang melibatkan pramugari kan. Kalau dulu Mas bagi halangan kepada pramugari untuk kahwin. Tapi kemudiannya sekarang ni dah tak ada dah. Okay, so to restraint of marriage, which relates to contract of service, that one is considered as a void contract. Kita tak boleh letakkan halangan. Cuma sekarang ni apa yang kebanyakan agensi penerbangan buat ialah bila pramugari dah kahwin and then find out that kalau kata pregnant dan sebagainya berada di office bawah lah, dia tak terbang lah. So ada kemungkinan anything can happen lah bila terbang ni, salin kat dalam flight ke apa ke, ataupun ialah bila mana terbang dia perlu bergerak banyak, mungkin atas terbang tu not suitable for pregnant woman lah untuk fly ke apa ke. Okay, so that's why sekarang ni dah tak ada larangan dah untuk pramugari. Tapi dulu pernah berlaku, kes dia bawa ke mahkamah against Mas. Pramugari bawa kes against Mas lah. Okay, so this one is sample of question. Seperti mana yang saya tahu tadi, untuk final exam nanti. Untuk final exam nanti focus on void and also voidable contract. We have lots of subtopic under the law of contract. We have offer, acceptance, consideration, intention, what else? Void, voidable, capacity to enter into contract, termination, remedies. Tapi untuk final exam nanti manakan final exam just around the corner, dan soalan pun dalam peringkat finalize yang sekarang. So please study, please read more on void and voidable. Bagi clue untuk final exam tadi. So ada apa lagi yang nak ditanyakan kelas? Okay, before we end this session today. Dah 2.50. Untuk next week nanti saya updatekan sama ada kita ada perjumpaan atau tidak, because on 28 till 30th of December I ada bengkel. But if I can get an excuse from organizer to have just 1 hour or 1 hour and a half to be with you, nanti I akan inform balik dalam group. Kita akan bincangkan on the topic of law of agency. Law of agency akan keluar untuk final exam nanti. Okay, because for your final exam will be 5 questions. So setiap soalan tu akan berdiri sendiri mengikut topik dia lah. Okay, law of contract. Satu soalan dia tak bercampur lah. Tak adalah kata satu A law of contract, B akan pergi law of agency, tak. Okay, satu A and B will fall under one topic. Kalau kata partnership akan akan 1A and B will be partnership lah, and then 2A to B will be company law macam tu. Okay, so kita akan ada 5 soalan. Law of contract, law of agency, sales of good, partnership, and also company. So ada 5 soalan, pilih 3 daripada 5 soalan. Okay. But no worries, okay. We'll share with you tips of final exam nanti bila kita dah habis perbincangan semua topik nanti. Okay, class, anything that you want to ask me before we dismiss? Okay, same. So far so good. Okay, kita jumpa. Okay, insyaAllah nanti apa-apa I akan updatekan next week. Okay. On which date yang kita boleh meet ni. So, Assalamualaikum and thank you everyone.
Thank you.
Okay, Doctor.